Appeal Fimbank Plc against KCH Shipping Co Ltd.
May it please my lords, I appear with my learned friend Ms Morton for the appellant bank, Fimbank. My learned friends Mr Rainey, King's Counsel, and Mr Chan represent the respondents who were at the relevant time the bareboat charterers of the vessel Giant Ace. This appeal concerns a cargo of 85,000 metric tonnes of steam coal shipped on board the vessel at East Kalamatan for carriage to and discharge and delivery at Indian ports. The issue in the underlying arbitration to which this appeal relates is whether or not my client's claims for wrongful misdelivery are time-barred by operation of Articles 3, Rule 6 of the Hague-Visby Rules. A panel which we accept was a highly experienced panel of maritime arbitrators concluded that the claims were time-barred. Mr Justice Butcher gave permission to appeal on two issues. First was whether Article 3, Rule 6 of the Hague-Visby Rules applies at all to claims for misdelivery of goods after they have been discharged. Second was whether, if so, Clause C of the 1994 Congen Bill of Lading form operates to exclude the operation of the Article 3, Rule 6 time bar. And it is common ground from the written cases in the appeal that the first of those questions, that is to say whether Article 3, Rule 6 applies to claims for misdelivery after discharge, can be divided into essentially three sub-issues. Firstly, whether or not Article 3, Rule 6 of the original Hague Rules prior to the Visby amendments operated to discharge bar claims for misdelivery after discharge. Secondly, whether the Visby amendments changed that position. And thirdly, if not, whether the parties, by incorporating the Hague-Visby rules generally into the Bill of Lading contracts, expressly or impliedly agreed that those rules, including the time bar, would nonetheless apply to claims arising after discharge. I propose to deal very briefly with the relevant underlying facts. They are all essentially agreed for the purposes of the appeal, but I think it's useful to look at the documents and deal with those briefly, and then to proceed straight to my submissions. The respondent was, as I said, the bareboat charterer, and issues 13 bills of lading, which are in the core bundle, tab 12.2, starting at page 339. 12.12, I'm sorry. The bills are, as I've said, on the Congen Bill 1994 terms, and I'd like, if I may, just to pick up on a few of the relevant provisions of those bills. We see in the top left-hand corner code name Congen Bill, and on the right-hand side, under the words Bill of Lading, the words to be used with charter parties. So this is a bill that envisages a close relationship with the charter parties. The bills were all consigned either to a company called Gokul Fuel Chem Pvt Limited, we see that under the notify address, or later on a different company, Bombay Rayon Fashions Limited, although nothing turns on that for present purposes. The port of discharge identified on the left-hand side about halfway down is any ports in India. The bills provided that freight was payable, one sees this in the left-hand box just below halfway down, freight payable as per charter party dated, but no date has been inserted, although, as I'll come on to mention, it's common ground which charter party that is a reference to. The operative part of the Bill of Lading on the right-hand side, beginning with the word shipped in capital letters, provides shipped at the port of loading in apparent good order and condition on board the vessel for carriage to the port of discharge, or so near thereto as she may safely get the goods specified above, and then below that for conditions of carriage, sea over leaf. And if one goes over the page to page 340, the standard conditions of carriage, Clause 1, all terms and conditions, liberties and exceptions of the charter party, dated as over leaf, and again, there was no date over leaf, but nothing turns on that, including the law and arbitration clause, are incorporated herewith. and then the general paramount clause 2A, B and C, clause 2 dealing with the position where the Hague rules are compulsory applicable, clause B dealing with the position where trades where the Hague-Visby rules apply, and then clause C, with which the final issue I'll come to early this afternoon is concerned, clause 2C, the carrier shall in no case be responsible for loss of or damage to the cargo, howsoever arising prior to loading into and after discharge from the vessel, or while the cargo is in the charge of another carrier, nor in respect of deck carriage or live animals. The bills therefore say nothing specific about delivery. They require the carrier to carry the goods to the port of discharge, or as near thereto as the vessel can safely get, and they provide for the carrier not to be responsible for loss or damage after discharge. The charter party referred to is at the previous tab in the core bundle, beginning at page 320. It provided on page 317 for the loading port to be 1-2 safe anchorages, 1 safe port Marara, and 1-2 safe anchorages, 1 safe port Samarinda, both in Indonesia, and for the discharge port at box 8 to be 1-2 safe berths, 1-2 safe anchorages, 1 safe port Jaigra. Clause 3.2 of the charter party is at page 320 and provides that the vessel shall discharge and deliver the cargo as and where directed by the charterers in compliance with clause 7 being the clause at page 321 that deals with loading and discharge rates. So the delivery provisions of the charter party are to deliver in accordance with the orders of the charterer. Most of the other provisions of the charter party are not, we would suggest, germane to the Bill of Lading contract and are therefore not incorporated by the words of incorporation. The clauses that are potentially relevant, if I can highlight those, are clause 13, which I'll come back to in a moment on page 323, but also clause 24, the lien clause at 327, clause 43, the general average clause at page 331, clause 54, the law and arbitration clause at page 335, which being specifically incorporated is why English law governs and the matter is being dealt with by arbitration in London. And then clause 59 at page 338, which provides in relation to the bills of lading, in case the original bill of lading not received by receivers on or before arrival of the vessel at discharge port, owners' masters agree to discharge and deliver the cargo to receivers against fax mail copy of charterer's letter indemnity as per owner's standard P&I Club wordings, duly stamped and signed by the charterers. So that is the provision, essentially, that obligated the bareboat charterers, my learned friends' clients, to discharge without production of the bill of lading. And the key provision, as I've said, and I said I'd come back to at page 323, 13.1, the master or his authorised agent on his behalf shall sign bills of lading as presented in the form presented by the charterer with a signed copy of authorisation to be provided to the charterer on demand. And then of particular significance for the hearing today, at 13.10, this charter party shall have effect subject to the Hague-Visby rules, which shall apply to any bill of lading issued under this charter party. Charterer shall have no liability to the owner in respect of any additional liability incurred by the owner by virtue of a bill of lading being compulsorily subject to the application of the Hague rules, the Hamburg rules, or the Rotterdam rules, or any other compulsorily applicable law or legislation in excess of any liability the owner would have incurred if such bill of lading had been subject to the Hague-Visby rules only. Apart from a passing reference in clause 45.2.4, which is the BIMCO ICE clause, the charter party says nothing about delivery itself, just as the bill of lading said nothing specific about delivery. But it's common ground that pursuant to the charter party, the vessel pursued to Jaigra and DG in India and discharged there between the 1st and the 18th of April 2018. against a letter of credit, a letter of indemnity as envisaged by the terms of the charter party. My client's case is that it had provided finance to the buyer of the cargo. My client's case, which is disputed in the arbitration but assumed for present purposes, is that it took security by way of a pledge over the bills of lading. It thereby became the holder of the bills of lading for the purposes of the carriage of goods by sea Act 1992. It was not paid by its customer, and that the respondent misdelivered the cargo to persons not entitled to receive it because they were not the holders of the bill of lading. And again, for the purposes of the appeal, it is common ground that it needs to be assumed that the misdelivery took place after discharge. The Court of Appeal observed, paragraph 12 of the judgment, I don't think we need to turn it up, but it's page 182 of the core volume. Delivery by a carrier without the bill is a breach of the contract of carriage. Liability in respect of such a breach is strict. It does not require proof of negligence or a failure of due diligence, and that liability can only be excluded by clear words. And it's the respondent's case that liability has essentially been excluded by operation of the Article 3, Rule 6, time bar as incorporated firstly into the charter party and thence into the bills of lading.
It's not excluded, is it? It's a limitation on when you can bring suit in respect of it.
Extinguished, I'm corrected. The arbitral tribunal identified and heard submissions on a number of preliminary issues, including whether Article 3, Rule 6 of the Hague and Hague-Visby rules, at that stage it had not been resolved which applied to the claim after discharge. The tribunal concluded that it was the Hague-Visby rules that were applicable, but it also concluded that Article 3, Rule 6 of both sets of rules, be it Hague or Hague-Visby rules, applied after discharge and that the claim was time-barred. My client sought permission to appeal in relation to a number of points. The application's at page 252, but again, I don't think we need to look at it. We were granted permission to appeal by Mr. Justice Butcher on just two of the grounds that we sought to raise, and they are essentially the two grounds that are still live before my lords today. Firstly, whether Article 3, Rule 6 of the Hague-Visby rules applied to claims after discharge, and secondly, whether Clause 2C operated to prevent that. It's important in our submission at this stage to note the process by which the tribunal proceeded at paragraph 75 of its reasoning in relation to incorporation of the Hague-Visby rules into the charter party. Probably an entirely orthodox approach, but if I could ask my lords to look at page 288, this is the tribunal's award at paragraph 75. Their approach to the incorporation of terms into the contract was essentially to write out the express terms of the bill of lading and the terms of the charter party to be incorporated and form a reasonable judgment as to whether they can fairly coexist in the same contract. They noted that the terms which are germane to the loading, carriage and discharge of the goods are more appropriate and more readily to be incorporated than terms which are not. And that's relevant to the two issues I'm going to come on to deal with towards the end of my submissions, namely whether if Article 3, Rule 6 of the Hague-Visby rules does not apply to claims arising after discharge, the manner in which the parties incorporated the rules evidences an intention that they should nonetheless apply in this contract. Going back to the proceedings below, the appeal was heard by Sir William Blair in July 2022 and dismissed with a costs order in favour of the respondents. That's page 203 of the core volume. Sir William broadly accepted the reasoning of the tribunal and essentially followed the same reasoning in dismissing the appeal. However, he granted permission to appeal to the Court of Appeal, and that appeal was heard in April 2023, but was also dismissed, and the order dismissing the appeal is at page 177. The judgment is at page 179, which we'll come to as appropriate. A unanimous judgment of Lord Justice Mayles, Lord Justice Popwell and Lord Justice Nugee. The Court of Appeal refused permission to appeal but we were granted permission by this court in October 2023, Lords Hodge, Leggett and Stevens granting permission. So turning to the issues that arise on the appeal, I propose broadly to follow the structure in our written case and to deal with what we submit are 11 key points. Firstly, as a matter of construction of Article 3, Rule 6 of the Hague Rules, they do not apply, we submit, to claims arising after discharge for broadly the reasons given by the Court of Appeal. Secondly, looking at the authorities in this jurisdiction, whilst none are directly on point, they support our construction of the Hague Rules. Thirdly, we submit there is a consensus in the international cases that supports that conclusion. Fourthly, and insofar as there is any doubt, the travaux préparatoires for the Hague Rules confirm the conclusion. Fifthly, as a matter of pure construction, looking at the amendments made by the Visby Protocol, Article 3, Rule 6 of the Visby Rules, the Hague Visby Rules, does not change the position. The time bar still is inapplicable after discharge. Sixthly, the cases, in fact just one case in this jurisdiction, although not directly on point, confirms that position. Seventhly, again, the international cases, whilst there are only two that we've been able to identify, confirm that conclusion. And eighthly, insofar as any doubt, again, reference to the travaux préparatoires for the Visby Protocol confirm that conclusion as to the construction of the rules. The ninth point, and assuming that we're right on Article 3, Rule 6 of the Hague Visby Rules, is that on a proper construction of the Bill of Lading contracts, the parties did not agree that the rules should have a wider application and therefore cover the position after discharge. Tenthly, and related to that, there is no basis for implying a term that the rules should continue to apply after discharge. And finally, if I'm wrong, and Article 3, Rule 6 of the Hague Visby Rules does apply to claims arising after discharge, our submission is that Clause 2C of the Congen Bill form of Bill of Lading does operate to exclude its operation. And so I will start with the Hague Rules. And it appears to be common ground that any analysis of Article 3, Rule 6 of the Hague Rules needs to start, of the Hague Visby Rules, needs to start, as I've said, with a consideration of the provisions of the Hague Rules. The Hague Rules were enacted into English law by the Carriage of Goods by Sea Act 1924. But for present purposes, nothing turns on the method of incorporation into English law because we're looking at the rules as part of the background to the Hague Visby Rules. In their written case, my learned friends go straight to Article 3, Rule 6 and look at Article 3, Rule 6 in isolation and only turn later to the rules as a whole. That's paragraph 25 onwards, their proposition 1. We suggest, and I intend to propose, proceed on the basis that it is more appropriate to look at the rules as a whole and to consider the part that Article 3, Rule 6 plays in the rules. And to that end, if I could turn to page 1233 in the core bundle, where we have the Hague Rules as originally enacted. I should say that this version is taken from a publication my lords see at the beginning, a League of Nations publication in their treaty series at 1218. It is very slightly different to the version that was appended to the Carriage of Goods by Sea Act in this jurisdiction, only in that each article had a heading which was underlined. We do have that version, but for present purposes I don't think anything turns on it. We submit that the relevant provisions begin at 1233, and they are the definitions, then Article 2, which engages the provisions of Articles 3 and 4, and then Articles 3 and 4. So we start with Article 1A. Carrier is defined to include the owner of the vessel or the charterer who enters into the contract of carriage with a shipper. Contract of carriage, by Article 1B, applies only, and I stress the words only, to contracts of carriage covered by a bill of lading or similar document of title, insofar as such document relates to the carriage of goods by sea. There are other provisions in Rule Article 1b, but they're not applicable for today's purposes. The relevant provision, as I say, is that contract of carriage for the purposes of the rule is a contract insofar as it applies to the carriage of goods by sea. Goods are defined in Article 1c, ship is defined in Article 1d, nothing turns on those definitions for present purposes, and 1e then defines carriage of goods as follows. Carriage of goods covers the period from the time when the goods are loaded on to the time when they are discharged from the ship. So we have a defined concept of carriage of contract of carriage, which is carriage of goods by sea, and a defined concept of carriage of goods, which is that part of the carriage beginning with loading and ending with discharge. Article 2 then provides as follows. Subject to the provision of Article 6, under every contract of carriage of goods by sea, so that's a reference back to the defined term from Article 1b and 1e, the carrier, in relation to the loading, handling, stowage, carriage, custody, care and discharge of such goods, shall be subject to the responsibilities and liabilities and entitled to the rights and immunities hereinafter set forth. We submit that is significant because Article 2 is essentially the gateway that grants to the carrier the rights and immunities set forth and makes the carrier subject to the responsibilities and liabilities set forth in both cases hereinafter. So Article 2 is in our submission saying that the subsequent provisions in Articles 3 and 4 set out the responsibilities, liabilities, rights and immunities that apply to the carriage of goods by sea. That is to say, that part of the contract beginning with loading and ending with discharge. And I'll come later to the judgment of Mr. Justice Devlin in Pyrene and Scindia, but he said in terms that it was Article 2 that granted those rights, responsibilities, and invoked those liabilities. And that package, as we would call it, or code of responsibilities, liabilities, rights and immunities, applies by the express wording of Article 2 and the definitions in Article 1b and 1e only to events after loading and before discharge. And Article 3 then sets out the key responsibilities of the carrier, including at Article 3.1 the obligation before and at the beginning of the voyage to exercise due diligence to, amongst other things, make the ship seaworthy.
So that doesn't just apply after loading?
My Lord is right in that the acts required to comply with that obligation need to be undertaken before loading.
Yes.
But insofar as it creates a liability, it is a liability in relation to the carriage of goods by sea, i.e. the period after loading and discharging. My Lord, that is a point that my learned friends make, and I will be coming on to deal with specifically. They say that the rules do in fact impose a number of obligations both before loading and after discharge, and essentially what we say is that although those obligations have to be performed before loading or after discharge, for example issuing the bill of lading, exercising due diligence by the carrier, giving notice by the cargo claimant, nonetheless they all relate to a liability or responsibility within the period of responsibility, the period beginning with loading and ending on discharge. So, as I say, Article 3.1 applies before and at the beginning of the voyage, and Article 3.2 then provides that subject to the provisions of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep, care for and discharge the goods carried. And that wording mirrors the wording from Article 2 that we looked at a moment ago. Article 3.3 then provides that after receiving the goods into his charge, the carrier or the master or agent of the carrier shall, on demand of the shipper, issue to the shipper a bill of lading showing, amongst other things, and again, as Lord Hamlin has said, that is something that requires action or activity before the loading period, but nonetheless it's activity relevant to the contract of carriage, i.e. between loading and discharge. Article 3, Rule 6 is the next provision that we would want to turn to, although noting that Article 3.4 provides that such a bill of lading shall be prima facie evidence of the receipt by the carrier of the goods described therein. And Article 3, Rule 6 is then at page 1235, and as my learned friend said, can conveniently be divided up into 4 parts. First provides that unless notice of loss or damage and the general nature of such loss or damage be given in writing to the carrier or his agent at the port of discharge before or at the time of the removal of the goods into the custody of the person entitled to delivery under the contract of carriage, such removal should be prima facie evidence of the delivery by the carrier of the goods as described in the bill of lading. Related to that, if the loss and damage is not apparent, the notice must be given within 3 days of delivery. The second provision, the notice in writing need not be given if the state of the goods has at the time of their receipt been the subject of a joint survey or inspection. And then the third provision, the one that my lords are concerned with, in any event, the carrier and the ship shall be discharged from all liability in respect of loss or damage and a suit is brought in 1 year after delivery of the goods or the date when the goods should have been delivered. The next provision of Article 3 that we submit is relevant is Article 3, Rule 8. This is, as my learned friends say, at paragraph 89 of their written case, the paragraph that creates the so-called irreducible minimum and prevents the carrier from contracting for more favourable terms. Any clause, covenant or agreement in a contract of carriage relieving the carrier or the ship from liability for loss or damage to or connection with the goods arising from negligence, fault or failure in the duties and obligations provided in this article, or lessening such liability, otherwise than as provided in this convention, shall be null and void and of no effect. In particular, it has been held, and we put this case into the supplementary authorities bundle in case it were relevant, in a case called the Ion by Mr. Justice Brandon, that a clause that seeks to impose a shorter limitation period, in that case 9 months, is void under Article 3, Rule 8. So Article 3, Rule 8 does operate not only in respect of all the other obligations and liabilities of the carrier, but in respect of the time bar as well. The main rights and immunities that the carrier is entitled to are then set out in Article 4, beginning at the bottom of page 1235. Article 4.1, providing that the carrier is not liable for loss or damage arising from unseaworthiness unless caused by a failure to exercise due diligence, that is to say, a breach of Article 3, Rule 1. Article 4, Rule 2 lists 16 matters for which the carrier is not liable in A to P, and then a sweep up at Q, dealing with any other cause arising without the actual fault or privity of the carrier. Article 4, Rule 4 deals with deviation, and Article 4, Rule 5 deals with package limitation. So those are the principal rights and immunities that the carrier is granted in relation to the contract of carriage for goods by sea. In other words, the contract beginning with loading, ending with discharge, or if the contract covers a wider period, that part of the contract beginning with loading and ending with discharge. And the final provision which we submit is relevant to the proper construction of Article 3, Rule 6 is Article 7, which provides that nothing herein contained shall prevent a carrier or a shipper from entering into any agreement, stipulation, condition, reservation or exemption as to the responsibility and liability of the carrier or the ship for loss of or damage to or in connection with the custody, care, handling of the goods prior to the loading on and subsequent to the discharge from the ship on which the goods are carried by sea. So that is the provision that, for the avoidance of doubt, preserves complete freedom of contract for the period both before loading and after discharge. And if I can, to come back to my Lord Hamlin's point, whilst the obligation to exercise due diligence has to be complied with prior to loading, Article 7 would not permit the carrier to exclude exercising due diligence prior to loading, because it would impact upon his performance of his obligations in relation to the contract of carriage. And that's why, as I say, provisions that are engaged both before loading and after discharge are still, in their effect, confined to the period of the contract of carriage. And events that take place, or liabilities that arise as a result of events before loading and after discharge, are in our submission subject to the law of the jurisdiction in which they occur, or to any express contractual agreement made by the parties as permitted under Article 7. And in that respect, it's important we submit to have in mind that the Hague Rules were, as is common ground, see, for example, paragraphs 93 and 134 of my learned friend's written case, a compromise between the competing commercial interests that were represented in the negotiation that led to the Hague Rules. And I'll be coming to the travaux préparatoire later. But what was important for cargo owners was to have an irreducible liability regime, including a longer time bar than was, some of the cases have used the phrase, commonly in vogue at the time of the negotiations. By preventing, by two routes. Firstly, by preventing owners from relying on the small print of their bills of lading. And if I can just pick up on that, I'll be coming back to it later, but to the decision in the Lenny at page 980 of the core bundle, just because there's a useful reference there to the underlying reasoning. The judgment starts at page 980, but if I can pick up just one short paragraph at 984, where Judge Diamond, Queen's Counsel, who also wrote a lengthy article in relation to the Hague and Hague-Visby rules, which my lords have been referred to, he said as follows at the bottom of the right-hand column. Second, I would have considered it important to have regard to what is known as the context and purpose of the 1924 Convention. Before 1924, there had been no statutory control in England of bill of lading clauses, with the result that ship owners had been able to introduce into the small print and the reverse of their bills of lading exceptions clauses relieving them from an ever-increasing range of liabilities. In some other countries, the legislature had already intervened, notably in the United States, and that's a reference to the Harter Act. Among the clauses that had been permitted at common law in England, and even in the United States and Canada under pre-existing legislation, had been contractual provisions barring claims unless written notice of claim had been given before removing the goods from the carrier's custody, or unless suit had been filed within periods as short as 30 to 60 days. And that's an important observation because it puts into context that Article 3, Rule 6 was originally a pro-cargo provision. In the context of this appeal, because it's the owners that rely on it and say it should apply after discharge, it's easy to regard Article 3, Rule 6 as a pro-owner provision. But its genesis, the origin of Article 3, Rule 6, was that it was there to benefit cargo, to prevent owners relying on what might be seen as ridiculously short periods of limitation. And also, to use a phrase, we don't need to turn it up, but was used by the Court of Appeal, I think, in the Janus NK, to rein in the owner's unbridled freedom of contract, which allowed them to impose in their contracts terms that were so unreasonable and unjust as to exempt them from almost any risk or responsibility. So the priority for cargo in this compromise represented the rules was to have an irreducible minimum. But, and we say this is important, what was important to carriers was to confine the period affected by the irreducible minimum or subject to the irreducible minimum to a period of responsibility clearly defined within the rules. Even though in this case, as I've said, it's the carrier that argues for a wide approach to Article 3, Rule 6, it was in fact a pro-cargo provision. And carriers in 1924 would have wanted to ensure that its scope, as with the other restrictions on their freedom of contract, was limited or at least clearly specified. And it's limited.
It's pro-cargo in the sense of the period. That's the point, isn't it?
Indeed, my lord. So it is saying, essentially, you can have a period of limitation, but it cannot be so unreasonably short as you are in the habit of contracting for without statutory or, as it turns out to be, international convention intervening. And the period is then fixed at 1 year. But one needs to say, in relation to which parts of the contract of carriage is that imposition of a 1 year period effective? And our submission is that just like all of the other rights, immunities and responsibilities and liabilities created by the Hague Rules and in due course the Hague-Visby Rules, that package has to apply within a clearly defined period, and that clearly defined period is what's been known subsequently as the period of responsibility, beginning with loading and ending with discharge.
So in relation to misdelivery after discharge, they can have a 30-day time limit, can they?
My lord, yes. Subject to any other statutory control in any relevant jurisdiction. But the period after discharge, there is complete freedom of contract. And indeed, as we'll look at when we come on to the very last issue in the case, even the possibility, as seems to be envisaged in Clause 2C of the Congen Bill, of agreeing no liability whatsoever, complete exoneration after discharge. And the importance is that if you're going to have a system where the carriage of goods by sea is subject to the control of the rules, there has to be clear defined start and end point when those rules are going to apply, and that clearly defined start and end point is good for all the provisions of the rules. Article 3, Rule 6 is not, as it were, an outlier. So we submit that looking at the wording of the rules by themselves, the conclusion which the Court of Appeal reached, that Article 3, Rule 6 of the Hague Rules was part of the package of rights, responsibilities and liabilities, that is clearly only applicable during the period of responsibility. My learned friends make a number of points in response, which I'm going to deal with. Not every single paragraph of their written case, but the headline points, if I may. And they're set out in the first 6 of their 8 propositions at paragraphs 17 to 24 of their written case, and developed thereafter. And my learned friends start by relying on what they say is the wide wording of Article 3, Rule 6. And in particular, they rely on the fact that it uses the word delivery 3 times. I'm not going to, unless we need to, pick up all the references, I'll just give them. That's paragraph 26 and following of their written case at page 130. So if I can deal with that to start with, again, by looking at Article 3, Rule 6, at page 1235 of the core bundle, it is correct that Article 3, Rule 6 uses the word delivery on 3 occasions. It is in our submission, however, wrong to suggest that that means that the time bar applies up to the moment of delivery. The first 2 uses of the word delivery appear in the first paragraph, and they are the time at which notice must be given to avoid an evidential estoppel arising. So we see, unless notice of loss or damage and the general nature of such loss and damage be given in writing to the carrier at the port of discharge before or at the time of the removal of the goods into the custody of the person entitled to delivery under the contract of carriage, such removal shall be prima facie evidence of the delivery by the carrier of the goods described in the bill of lading. And the word delivery in those 2 contexts says nothing about the time period within which a time bar operates. It simply specifies the times that have to be complied with by the party taking delivery.
So if goods were damaged after discharge but before delivery, you say the Hague rules or Hague rules don't apply then, but you have a liability as a bailee. This provision would apply, wouldn't it?
My Lord, on our case, no, because no part of the provision would be applying. So no part of the rules would be applying after discharge. So there would be no question, just as there would be no question of the time bar under Article 3, Rule 6 applying after discharge, there would be no question of the evidential presumption created by the first paragraph applying to the loss and damage after discharge. This is simply a provision that specifies when the cargo receiver, the party taking delivery, must give their notice in writing to give rise or to avoid the evidential presumption.
I mean, on the face of it, it does seem to cover the situation that my Lord mentions, that namely damage between discharge and delivery in breach of obligations as bailee, because how do you prove your case if that is the nature of your case? Ordinarily, you would say, well, I received damaged goods or didn't receive goods at all, and that this provision seems to be aimed at fixing people with what goods they did receive and in what condition.
Indeed, but the rationale for picking that time, i.e. evidence of delivery, is that prior to actually having delivery, the cargo receiver can't know whether the goods are or are not in good condition. It's simply a pragmatic acknowledgement of the fact that would be the earliest at which it would be fair or reasonable to impose an evidential presumption, because until the cargo receiver, consignee, takes delivery, they can't be in a position to give the notice. It simply reflects the fact that until that moment they're not in a position to give the notice.
Right, but isn't the logic of wanting to have some sort of fixing, prima facie rule fixing people with information about the state of the goods when delivered, that rationale would apply, wouldn't it, also to a case where there has been damage between discharge and delivery in breach of obligations of the of bailment? The reasons that I was just giving to you, that how do you prove that there's been some breach of duty? You say, well, I was given some damaged goods at the end of the day.
Indeed, my Lord, I think one has to approach it with respect the other way round. This is a provision that is saying that unless the receiver gives notice, and obviously the receiver can only give notice once they've taken delivery, then taking delivery is prima facie evidence that the goods were in good condition on delivery, or say good condition, in the condition described in the bill of lading. So if the receiver, with the bill of lading in their hand in this context, accepts delivery, that creates a prima facie evidence that the goods are in the condition described in the bill of lading for the purposes of considering the liabilities of the carrier in relation to the contract of carriage as defined. So I can see that it still might create, as a matter of, for example, English law, or just a working assumption that the goods were in the same condition. But for the purposes of the package of rights and immunities under the Hague rules, it would be our submission that in terms of creating a prima facie case as set out in the rules, that's only good for a claim made in respect to the period before discharge, for damage caused before discharge. But my Lord, I can see that because of the simple fact of taking delivery of goods which may be damaged or may not be damaged, but you have the bill of lading, you compare the condition of the goods to the condition described in the bill of lading, I could see that might, in effect, give rise to an evidential presumption that the goods were in a good condition.
Well, it seems to say so, but the interest of the goods owner will be to disarm that presumption by giving it notice.
And that they have to give notice at the time of taking delivery. But that's still in relation to the period of responsibility governed by the rules. So
if you gave notice, could you not rely on that displacing the presumption even if the damage was caused after discharge?
My Lord, yes, but not by operation of this paragraph of Article 3, Rule 6. You wouldn't need Article 3, Rule 6 in that sense, because you would be receiving the goods and immediately saying these are not in good condition. This rule is creating a presumption in favour of the carrier in relation to the performance of its obligations during the period of responsibility, but to give the receiver the opportunity to inspect the goods before that presumption arises is giving a start date of the taking of delivery.
I mean, in a sense, it would be by virtue of this rule, because the rule sets up this evidential presumption, which would seem to cover not just the situation during the period of responsibility, as you call it, but also things which have gone wrong between discharge and delivery. So if you don't give a notice and you, as the goods owner, receive the goods, on the face of it, you seem to be stuck with this evidential presumption that the goods were fine when you got them. And this rule seems to set out its own regime for how you disable, having set up that presumptive regime, how you disable that presumption by giving a notice. But what I'm struggling to follow is why you say that this presumption and notice regime only applies in relation to things that have gone wrong during the period of responsibility. It, to my mind, at the moment, seems to cover also things that have gone wrong between discharge and delivery.
My Lord, can I go back a step?
Yeah.
If one were to have a provision, the intention of which is to create an evidential assumption, limited in its scope to damage caused during the period of responsibility, you would still have to have the date of delivery as the trigger date in order to give the receiver an opportunity to look at the cargo and inspect it before the evidential presumption took effect. So in our submission, the use of the word delivery in this context is merely a pragmatic recognition of the fact that it would not be appropriate to give rise to an evidential presumption against the receiver at a time when he had not yet seen or taken delivery of the goods and therefore had an opportunity to inspect them. So I can see that in practical terms, because the period between discharge and delivery has then elapsed, such an estoppel might be relevant in relation to the post-discharge period. But it still doesn't alter the fact that Article 3, Rule 6, as part of the package of responsibilities and liabilities, and certainly when we come on to look at the limitation provision, the 1-year period, it doesn't alter the fact that that is part of the package which is, we submit, confined to the period of responsibility.
And one last question, if I may, just on this. I mean, it says prima facie evidence of the delivery of the carrier, by the carrier of the goods as described. I mean, if it was intended to be confined to prima facie evidence that they've fulfilled their responsibilities during the period of responsibility, couldn't that have been expressed in terms of prima facie evidence of the due discharge of by the carrier of its obligations as set out in these rules, or something like that? Whereas, as expressed in terms of evidence of the delivery, that seems to cover both that and the sort of situation that Lord Hamlin was putting to you.
My Lord, I can't avoid the fact that that is the consequence of the use of the word delivery in that one of those three instances. But in our submission, that the fact that there might, because of the giving of notice, that might prevent an evidential assumption arising, that is not sufficient when looking at Article 3, Rule 6 as a whole and the time bar, which I'm coming on to mean that there is an intention that the package contained in Article 3, Rule 6 should be an outlier to the rest of the package.
Yes, all right, thank you.
My Lord, I see the point in relation to the evidential presumption, but in our submission it is no more than that, because once you allow the receiver sufficient time to inspect the goods, you have to use delivery as the cut-off point for the purposes of the evidential presumption.
Yes, all right, thank you.
And in one sense, using delivery as a point in our favour, because it recognises that there is a gap between discharge and delivery. And then the third use of the word delivery is in the operative, the third paragraph of Article 3, Rule 6 that we looked at earlier, and that the time bar arises unless suit is brought within 1 year after the delivery of the goods. But again, in our submission, all that is a provision that starts the clock running for the purposes of the limitation period and recognises that it would not be fair to impose the obligation to commence suit on the receiver other than by reference to the period when he received the goods. And so it does not support the suggestion, as my learned friend says, that somehow this evidence is an intention to take Article 3, Rule 6 outside the package that is contained within the rest of the Hague Rules. And so that was the first point in relation to the wording of Article 3, Rule 6 that my learned friends rely on. The second, paragraph 29 and following of their written case, is what they describe as the wide wording of the rules and the use of the words in any event and in every case. So in any event, the charterer shall be discharged from all liability. My learned friend's submission is that the words in any event should be read as to mean in every case. That is to mean including cases arising outside the period of responsibility. In our respectful submission, that's not the correct approach. The words in any event, or in the French text, en tout cas, simply mean that the time bar applies irrespective of whether notice has been given under Article 3, Rule 6, first paragraph. So it's simply saying whether or not notice has been given, the time bar will apply. And that was the conclusion of Lord President Thomson in the Rambler Cycler case, which I'll be coming on to later. I don't want to take it out of turn unless I need to, but it's page 46 of the report in the right-hand column. And my learned friends rely on the decision of the Court of Appeal in the Captain Petko Voivoda, which I will turn up if I may. It's at page 524 of the core volume. That was a case that involved the same words in any event, but in Article 4, Rule 5. So at page 524 of the core bundle, the question, as I've said, was whether a carrier who had carried on deck in breach of the contract of carriage could still rely on Article 4, Rule 5. The ratio of the decision we can see in the first paragraph under held. The Hague Rules, even when incorporated into a contract governed by English law, were an international convention and had therefore to be construed on broad precedents of general acceptance rather than rigidly controlled by domestic principles of antecedent date. The approach was very relevant to the peculiar common law principle derived from the deviation cases, and the argument essentially was that carrying on deck was a quasi-deviation and therefore deprived the carrier of the rights under Article 4, Rule 5. And Lord Justice Longmore, who gave the leading judgment, referred to the fact that in the courts of France, Italy and the Netherlands, the courts had decided that a carrier could rely on Article 4, Rule 5. And then we see from paragraph 2 of the headnote, the most natural construction of the words in any event in Article 4, Rule 5 of the Hague Rules was in every case. And that's the paragraph that my learned friends rely on, say that it means in every case. And that was supported by the French wording on aucun cas. Now, of course, my lords, that in French is a very slightly different wording from en tout cas in Article 3, Rule 6. En
tout cas doesn't mean in every case. It means at all events or something like that, or in any event.
And en aucun cas, probably something slightly wider in our submission. My lord, that was exactly the point I was going to make. So my learned friends rely on what Lord Justice Longmore said, and I have to accept that he did say that it would be strange if the words in any event had a different meaning in Article 4, Rule 5 to Article 3, Rule 6. But in our submission, That is wrong, and I will develop the reasoning for that. Firstly, in relation to the construction of the words "in any event," as I said, it is correct that Lord Justice Longmore did say at paragraph 17 on page 534 of the core bundle, it'd be curious if those words had a different meaning in Article 4, Rule 5 from that which they had in Article 3, Rule 6. And we say, well, not necessarily, because the French text is different. More significantly, what Lord Justice Longmore said at paragraph 16, if I can refer back to this, once the problem is treated purely as a question of construction, the words "in any event" become very important. The most natural meaning to my mind is "in any case," in every case, whether or not the breach of contract is particularly serious. Whether or not the cargo was stowed under deck, the French wording "en aucun cas" would, I think, support that view. And there's then a reference to the judgment of Mr. Justice Hurst. And then Lord Justice Longmore went on as follows. Mr. Hamlin submitted that the phrase was, as he put it, conjunctive and neutral, and meant no more than, notwithstanding the foregoing. Since the rule foregoing Article 4, Rule 5 is Article 4, Rule 4, disapplying the strict common law rule about deviation, it does not seem to me that Mr. Hamlin's construction particularly advanced the argument. And in our submission that in the context of Article 3, Rule 6, and particularly when we're looking at the third paragraph of Article 3, Rule 6, coming after the first paragraph, that reasoning does not apply to Article 3, Rule 6. Put another way, the reason why Lord Justice Longmore would not accept or did not accept Mr. Hamlin's submission in that case was that referring back to Article 5, Rule 4 didn't really make any sense in the context of Article 4, Rule 4, didn't make any sense in the context of the debate whether Article 4, Rule 5 applied. In our submission, however, in our case, in Article 3, Rule 6, using the words "in any event" in the fourth paragraph of Article 3, Rule 6 to refer back to the first and second paragraphs, i.e. whether notice has been given, does make sense, and that therefore the conjunctive and neutral approach does apply. And so, in our respectful submission, my learned friend's reliance on the decision in the Captain Petco Voivoda does not, in fact, take them any further. On the contrary, as Lord Justice Mayles said at paragraph 64 of the judgment in the Court of Appeal, in this case, page 195 of my Lord's bundle, in fact, citing Lord Justice Longmore's subsequent decision in the MSC Amsterdam, the words "in any event" cannot support an argument that the time bar applies even when the rules do not. And in our submission, that is the correct conclusion. So the words "in any event" don't assist my learned friend. The next point, in terms of the wide wording that my learned friends rely on, is the width of the words "from all liability." And they cite the decision of the Privy Council, the advice of the Privy Council in the New York Star, which my lords have at page 799 of the core bundle. This was a case in which a stevedore unloaded the ship and placed the cargo on part of the wharf under its control.
I'm sorry, could you just give the page now?
799, my lord. The core bundle. If my lord has tabs, it's 14.70.
Sorry, thank you. Yes, I have it.
A case in which the stevedore unloaded the cargo and placed it on a wharf that it controlled and later delivered it to thieves who did not have the bill of lading, and the stevedore was subsequently sued. And a number of different questions arose, in particular whether the stevedore could claim the benefit of the time bar in the bill of lading contract. The wording of the time bar, clause 17 of the bill of lading in this case, was materially identical to Article 3, Rule 6. And it's correct that Lord Wilberforce at page 806.
So it is a misdelivery case.
It is, my lord, yes, but it's a misdelivery case where the time bar exists by itself, essentially in a vacuum, without the benefit of all the other provisions of the Hague Rules that form part of the package of rights and responsibilities. And it is correct, as I was about to say at page 806, as my learned friends rely on, that Lord Wilberforce described clause 17, as I say, in materially identical terms to Article 3, Rule 6, as being general and all-embracing. That's the first full paragraph at the top of page 806. And it's also correct, as my learned friends say, at page 808, in the middle of the page, letter E, Lord Wilberforce said that these provisions must be interpreted in the light of the practice that consignees rarely take delivery of the goods at the ship's rail, but will normally collect them after some period of storage on or near the wharf. And I raise that because my learned friends rely on that when we come on to look at the Hague-Visby amendments. They say it would have been well known that delivery normally comes sometime after discharge.
I think they also rely on what's said at 145C. First two sentences. You see, the reference to delivery of goods shows clearly the clause is directed towards the carrier's obligations as bailey of the goods.
My lord, I'm sorry, I had the wrong
All
page.
liability means what it says.
806 at C.
My lord, yes, I'm sorry, I was looking at the previous page that I'd gone on to. My lord, entirely. But our submission in response to that, and it all goes with the reliance on the earlier wording as well, is that all of that is in the context of this clause standing by itself. If one were just looking at this clause by itself and not in the context of a package of rights and immunities, the product of an international convention and compromise by both sides that draws a line and says this package of rights and responsibilities will apply to a certain part of the contract, but not to others.
But it would apply to tortious liabilities during the period of responsibility, wouldn't it?
My lord, yes. My lord, yes. And to misdelivery during the period of responsibility. That, in due course, is the decision of Mr. Foxton QC, as he then was in the Alani, as well as other cases. And that, in fact, is the next point I was going to address. My learned friends rely on the fact that the words loss and damage in Article 3, Rule 6 are wide and all-encompassing, and they say capable of encompassing claims in tort, claims for misdelivery. And we say, well, yes, that may be a good point as a matter of, certainly of English law, if one was considering whether claims in tort are covered by the time bar, but it's none to the point as to whether the time bar is engaged after discharge. It's a neutral point in that respect. And fourthly, paragraph 37 and following of their written case, my learned friends rely again on the use of the word delivery, but I've covered that already in my earlier submissions. And in our submission, none of the points my learned friends make undermines the force of our underlying point that Article 3, Rule 6 is part of the package of rights and responsibilities that only applies during the period of responsibility. They also rely on the decisions in the O.T. Sonia and the Sophie J, but I'm going to come on to those later when I look at the English authorities, if I may. Next, my learned friends rely, and this is paragraph 68, on the fact, as they say, that Article 3 sets out various rights and responsibilities and liabilities, and that the rights and immunities, as referred to in Article 2, are contained in Article 4. I mentioned that point already when I referred to the fact that the rules as scheduled to the 1924 Act have headings, and it's correct, as my learned friend says, that Article 3 is headed responsibilities and liabilities, and Article 4 is headed rights and immunities. My learned friends then go on to say, at paragraph 73, that Article 3, Rule 6, although part of Article 3, doesn't create a responsibility or a liability, and therefore is not one of the provisions that is engaged by Article 2. So my Lord will recall my submission was that it is Article 2 that grants the carrier the rights and immunities and that exposes him to the responsibilities and liabilities hereinafter set out. And my learned friend's submission essentially is that Article 3, Rule 6 doesn't form a responsibility or liability and therefore is not one of the provisions to which Article 2 is the gateway. In our submission, that misunderstands how Article 3 operates. And if I could ask my Lords to have it open again at page 1233. Because Article 3, both Rules 1, 2 and 3, are all setting out responsibilities of the carrier. None of them, as such, set out or create liabilities. Liabilities arise where there is a breach of the responsibility. They define what the carrier is obliged to do. And my learned friend's submission, we would suggest, is oversimplistic. Article 3, if it has the heading responsibilities and liabilities, proceeds on the basis that all of the provisions of Article 3 are dealing with the responsibilities of the carrier and the liabilities that arise for breach of those responsibilities. And Article 3, Rule 6 is as much a part of that package because it sets out the circumstances in which that liability might be discharged as Article 3, 1, 2 or 3, which set out the circumstances in which that liability might arise. And so in our submission, Article 3, Rule 6 is concerned with responsibilities and liabilities and is one of the provisions that Article 2 opens the gateway to.
So you're saying that they're subject to a liability under Article 3, Rule 6?
I don't think I have to go so far as to say subject to a liability, but Article 3, Rule 6.
That's what Article 2 says, isn't it?
Subject to the responsibilities and liabilities. Indeed. I suppose one could put it this way round, that if the liability is discharged by Article 3, Rule 6, the carrier is no longer subject to that liability. So Article 3 is setting out responsibilities and liabilities, but nowhere in Article 3 is any liability created as such. One has to assume that a liability arises when there is a breach of the responsibility. And so in dealing with responsibilities and liabilities, the carrier, one could put it this way round, is subject to a liability unless it is discharged by suit not being brought within a year. But if Article 6 isn't dealing with liabilities, then it's difficult in our submission to see which provisions of Article 3 are subjecting the carrier to liabilities. And that conclusion is, we would suggest, confirmed by the fact that Article 8, as I've said, certainly as a matter of English law, prohibits the carrier from contracting for a shorter limitation period. See, as I've said, the decision in the Ion.
You mean Rule 8, do
My,
you? Rule 8?
Article 3, Rule 8.
Yes.
Sorry, did I say?
Article 8.
I do apologise. Article 3, Rule 8. I'm sorry, my lord.
Does the original text have the headings or not?
In the Carriage of Goods by Sea Act 1924, yes. In the original text of the Convention, no.
Well, we're interested in the convention, not the English enactment, aren't we?
Indeed, my lord, but I was dealing with the point my learned friends make in their written...
I know, I was just interested in whether it does or doesn't have the headings in the text.
My lord, there are no headings in the version, which is why I've been taken, my lord, to the League of Nations Treaty Series that is at 1, 2, 3, 3 for these purposes. And my learned friends then at paragraph 115 go on to suggest that there cannot have been any intention to create what they call a split regime of time bar, with one period applying up to the moment of discharge and time at large thereafter. And in our submission also, that is a false point, because the rules clearly do create a split regime. It's inherent in the definitions that I took my lords to at the outset. But there is a split regime whereby the package of rights and responsibilities, immunities and liabilities created by the rules applies to the contract of carriage by sea, but not otherwise. And so to suggest that there can't be a split regime in relation to the time bar overlooks the fact that there is inevitably a split regime in relation to everything else covered by the Hague Rules. I've dealt with already, and won't come back to, my learned friend's point that some of the obligations under the rules arise before loading and continue after discharge. That's a neutral point. And so in our submission, none of the points my learned friends make in their section of their written case dealing with the proper construction of the rules in any way displaces the conclusion that we argue for. The final argument to address, however, is that our approach involves practical problems and anomalies, and that was a point that the Tribunal and indeed Sir William Blair were particularly concerned about. In our submission, it's a non-point for two main reasons. Firstly, the alleged difficulty in identifying whether an act or omission of the carrier occurred during discharge or before discharge is much more apparent than real. In our submission, in practice, it would usually be relatively easy to identify which side of the line a particular case falls. No doubt a wide meaning will be given to loading and also to discharge, but it will always be clear whether the claim arose before the loading process started or after the discharge was complete. And insofar as there is a factual dispute about that, is the kind of factual dispute which maritime arbitrators and judges of the Admiralty and Commercial Court are well used to dealing with. Secondly, and perhaps more importantly, that dividing line needs to be identified come what may, because it's the dividing line that defines whether the package of rights and responsibilities under the rules applies. So even if Article 3, Rule 6 is not prescribed by the period of responsibility, the rest of the Hague Rules are, and so it's always going to be necessary to identify where that dividing line arises. Test, for example, if the carrier contracted for different terms in relation to his liability than those contained in the rules, one would need to consider whether the claim arose before or after discharge or before or after loading commenced. So, my lords, having looked at the rules themselves as a matter of construction, I'd like to turn briefly, if I may, to the cases in this jurisdiction under the Hague Rules, although none of them are directly on point and therefore they are no more than illustrative of what we say is the right approach. The first, I'll take these in chronological order because they show the development of the jurisprudence. The first is the decision of Mr. Justice Wright in Goss Millard, which is in the core volume of page 603. This case concerned two packages of cargo, and as a matter of fact, Mr. Justice Wright reached a conclusion as to the cause of the damage in relation to one package, but not the cause of the damage in relation to the other package, which he held had not been explained. And he therefore needed to go on to look at the rules to consider where the burden of proof lay. And the point that we rely on from this case arises at page 605, 434 of the report, but 605 of the core bundle, where Mr. Justice Wright observes at the beginning of the first full paragraph, these rules, which now have statutory force, have radically changed the legal status of sea carriers under the Bill of Lading. And then further on in that paragraph, he observes, sets out the provisions of Article 3, Rule 2, which, as I said, reflect the wording of Article 2, and then says the word discharge is used, I think, in place of the word deliver, because the period of responsibility to which the Act applies and the rules apply, Article 1E, ends when they are discharged from the ship. And so that in our submission is the clearest indication that there is a period of responsibility that ends at the moment of discharge. We accept, of course, that none of that formed part of the ratio of Mr. Justice Wright, but nonetheless it was an observation and analysis that Lord Justice Longmore referred to in the MSc Amsterdam, which we'll look at in due course with approval. That's paragraph 22 to 23 of the judgment. And in the same judgment, Lord Justice Longmore also went on to refer to the dictum of Mr. Justice Devlin in Pyrene and Scindia, which I've already referred to briefly, but it's page 810 of the core bundle. In that case, the claimant's or the plaintiff's fire tender had been dropped and damaged during the course of loading, but before it crossed the ship's rail. A number of issues as to the applicability that Hague Rules applies in context where the carrier sought to limit its liability under Article 4, Rule 5. One of the issues was whether the accident was outside the period of responsibility because the tender had not yet crossed the ship's rail. At page 823, Mr. Justice Devlin set out the contentions of counsel, beginning at the bottom, in fact, of page 822, where he refers to the submissions of Mr. McGraw, and then, and perhaps worth just pausing and looking at them. Mr. McGraw contends, therefore, that the accident occurred outside the period specified in Article 1E. So he says the rules, Article 4, Rule 5, which limits liability, and indeed all the other rules which regulate the rights and responsibilities of the ship owner, do not apply. They are made applicable by Article 2, so it seems to be common ground there that the rules are made applicable by Article 2, which is our case, which provides that under every contract of carriage, and then the provisions of Article 2 are set out. And then the conclusion in relation to that submission is the first full paragraph at page 823. In my judgment, this argument, which was that there was a time limit, effectively, is fallacious. The cause of the fallacy perhaps lying in the supposition inherent in it that the rights and liabilities under the rule attach to a period of time. I think that they attach to a contract or part of a contract. I say part of a contract because a single contract may cover both inland and sea transport, and in that case the only part of it that falls within the rules is that to which, to use the words of the definition of the contract of carriage, relates to the carriage of goods by sea. And then at the next paragraph, Article 2 is the crucial article, which for this purpose has to be construed. It is this article that gives the carrier all his rights and immunities, including the right to limit his liability. Although Mr. Justice Devlin was not there concerned with time limitation, we would submit that would also say, including the right to a one-year time bar. And then if we can go to page 824 in the core bundle, in the middle of the page, picking up about halfway through the paragraph, I'm looking at the words, the obligations in Article 3, Rule 1, for example, to use due diligence to make the ship seaworthy and man and equip her properly, are independent of time. And that perhaps touches on my Lord Hamden's point. The operation of the rules is determined by the limit of the contract of carriage by sea and not by the limit of time. The function of Article 1E is, I think, only to assist in the definition of the contract of carriage. As I've already pointed out, there is excluded from that definition any part of a larger contract which relates, for example, to inland transport. One could pause there and say, or the storage of the cargo after discharge. It is natural to divide such contract into periods, a period of inland transport followed perhaps by a period of sea transport. And so, my lords, in our submission, the analysis there, again, whilst not directly on point, is entirely supportive of our construction of the rules. And the same applies to the decision in the Arawa, which is at page 912 of my Lord's bundle. This was a decision of Mr. Justice Brandon, and in that case the claimant's cargo had been lighted from the carrying ship, from the ocean carrying ship, to enable her to meet her schedule. And Mr. Justice Brandon held on the facts, we see this from the head note, that the cargo was damaged because of a subsequent delay in discharging it from the lighters at the warehouse due to industrial action. This was all attributable to the negligence of the Chambers Wharf, and the issue that arose was whether the ship owners were liable for the wharf's negligence. And to answer that question, Mr. Justice Brandon posed 8 questions, which are in fact set out at paragraph 918 of his judgment, beginning in the bottom of the left-hand column.
Could I have a page number, please?
918, report page 422, my Lord, at core bundle 918 in the left-hand column. Mr. Justice Brandon set out the 8 questions there, including question 5. If, on the other hand, the ship owners dealt with the cargo subject to the various terms relating to liability for damage to cargo contained in the bills of lading, which of those terms applied? In particular, did the liabilities and immunities contained in Articles 3 and 4 of the Hague Rules, as incorporated by Clause 1 of the Bill of Lading, apply on the basis that the cargo was still in the course of discharge? So the cargo had been discharged from the carrying ship, was in lighters, but had not been discharged ashore. In the event, in answer to the first question, Mr. Justice Brandon concluded that the lightering had not been authorised, but in response to the second question, he concluded that nonetheless the cargo owners had accepted the arrangement, so they couldn't complain about the lightering. In answer to the third question, Mr. Justice Brandon held that after discharge the ship owners were common law bailies for reward, that's page 920, such that they were liable for the negligence of the wharf. The remaining questions, therefore, didn't arise, but Mr. Justice Brandon nonetheless dealt with them, and again, I have to accept that this is obiter and not directly on point, but he sets out what he describes as the scheme of the rules at page 920, right-hand column, foot of the page, going over to 921, the left-hand column. And we've set these out in our written case. But again, the scheme of the rules, as Mr. Justice Brandon, as he then was, set them out, particularly at little 3, Roman 3, at the bottom of page 920. The parties are free to decide by their contract what parts of the operation of loading the goods on and discharging from the carrying ship are to be performed by the carrier, and what parts the shipper or the receiver, and that's a reference to Irene and Celia. And then at 4, the liability of the carrier for loss or damage to the sea goods during the sea carriage, as defined in 2 and 3 above, is governed by Articles 3 and 4 of the rules. And then 5, the liability of the carrier for loss of or damage to the goods before the beginning or after the end of the sea carriage, as defined in Articles 2 and 3, in paragraphs 2 and 3 above, is not governed by the rules. So again, the clearest possible statement that after discharge the rules are of no application. And then finally, in relation to the English cases that we submit assist, my Lords, the most recent decision of Mr. Foxton QC, as he then was in the Alani, which my learned friends refer to as well, which is in the core bundle at page 542. In that case, Mr. Foxton had to consider 2 issues. The first was whether Article 3, Rule 6 applied to a case of misdelivery at all. And in that case, the misdelivery was during the course of the voyage, or at least simultaneous with discharge. So the cargo was discharged by pumping into another vessel by ship-to-ship transfer, the misdelivery took place at that stage, so delivery and discharge taking place at the same time. The cargo owner brought proceedings alleging, amongst other things, breach of the obligation only to deliver against the bill of lading. And as I say, the issue was whether Article 3, Rule 6 applied at all to misdelivery. So the issue of whether it applied after discharge did not apply. And Mr. Foxton nonetheless said at page 551, we submit correctly and reflecting all the analysis we've looked at before, at paragraph 26, unless the parties agree to an extended operation, there is a temporal sphere of operation to the Hague Rules, usually referred to as the period of responsibility. And Mr. Foxton also referred at paragraph 20 to the process of negotiation that had led to the Hague Rules, under the heading of the Hague Rules at 549. And he referred, as the other cases I've referred, my lords, to the one-sided nature of the contractual terms that ship owners had been in the habit of imposing. He referred particularly at paragraph 25 of relevance to my lords that the issue of what constitutes loading and discharging for the purposes of the rules is approached in a practical way dependent on the parties' bargain. And that goes to my learned friend's point about practical difficulties. And Mr. Foxton then set out the arguments of cargo at paragraphs 36 and 37, including, importantly, the argument that Article 3, Rule 6 only applied to claims for breach of a Hague Rules obligation. And that is the argument that Mr. Foxton, as he then was, principally declined to accept, holding that the rules applied, and this is the point my Lord Hamlin raised earlier, not only to breaches of the Hague Rules obligations, but to any other breaches, provided they were within the period of responsibility. And we submit that there are two key takeaways from the decision in the Alani. The first is, as I've stressed, it's a further reference to the importance of the period of responsibility. And the second is that it shows that under the Hague Rules, there was a lack of clarity as to whether Article 3, Rule 6 applied to misdelivery at all, or indeed to any claims for breach of other obligations than the Hague Rules obligations. Indeed, Mr. Kenny, in that case, argued, albeit unsuccessfully, that there was a settled understanding that the rules did not apply, or the time bar did not apply, to breach of obligations other than the Hague Rules obligations. And Mr. Foxton rejected that submission, but it illustrates in our submission, this is important when we come on to look at the Visby amendments, that certainly at least until the decision in the Alani, it was undecided whether the rules applied to breaches of non-Hague Rules obligations, whether Article 3, Rule 6 applied. And my learned friends rely on three particular cases which they say point the other way. And as I've said, the English jurisprudence, none of these points are cases are directly on point. The third is the New York Star, which I've already dealt with and I'm not going to come back to again. The first is the decision of the Court of Appeal in the OT Sonia, which I've already referred to briefly, and that's at page 502 of the core volume. In the OT Sonia, the Charter Party incorporated the United States Carriage of Goods by Sea Act. Section 3.6 of that Act is materially identical to Article 3, Rule 6. The claimants advanced two claims. The first was that in breach of the Charter Party, the vessel presented for loading with dirty tanks that were unsuitable for carriage of the cargo, and that caused delay to the start of loading, causing financial loss to the claimants. The second was that at the second load port, cargo which was thought to be contaminated was permitted to leak from one tank to another, causing further financial loss. And the Court of Appeal identified two issues, Lord Justice Hurst at page 504, left-hand column. The first was, do the words loss and damage refer only to physical loss and damage, or did they extend to loss and damage related to the goods? That issue, in one sense, had nothing to do with the question of whether the time bar applies to claims arising after discharge. But it is, however, relevant for the same reasons as I mentioned that Mr. Foxton's judgment was in the Alani, because it illustrates that certainly until the decision in the OT Sonia, it was not clear whether the words loss and damage applied to purely financial loss, where there was no physical loss or damage to the cargo. The second issue identified was whether the time bar operated when the goods to which the loss related had never in fact been loaded on the vessel. And in this case, some of the cargo was never loaded, but the Court of Appeal nonetheless concluded that the time bar applied, and my learned friends rely on that, and they say, well, that shows that there is a wider ambit to the time bar because it applies even when the goods are not loaded, so it can't be confined to the period between loading and discharge. And it's the Court of Appeal's conclusion on that latter point that my learned friends rely on. In fact, however, we submit that when one looks at the Court of Appeal's judgment, and on this issue it's very short at page 511, it does not support my learned friend's case. And it rises and starts at the left-hand column, heading question 2. And Lord Justice Hurst sets out there, Mr. Broadbent submits that the loss or damage must be related to the goods actually loaded on the vessel. That's the last full paragraph. And then going over the page, going over to the right-hand column, the conclusion begins where, as is alleged here, goods destined for the vessel were not loaded due to the delay. It seems to me that the resulting loss and damage is manifestly in relation to the goods. Seeing that adopting Mr. Justice Devlin's test in the Adamastos case, it arises in relation to the loading, handling, stowage, carriage, custody, care and discharge of such goods. And so essentially what Lord Justice Hurst was saying was that the claim arises out of defaults of the carrier in relation to the loading of the goods. And even if those defaults led to the goods not being loaded, they are within the period of responsibility. And so this case in our submission does not assist my learned friend because it's still focused on identifying whether the acts complained of arose as part of the loading process. And in the OT Sonia in our submission they did. And the same analysis assists in relation to the decision of Mr. Justice Tomlinson in Linea Nevera, which is the other case my learned friends rely on. And we accept, page 701, I should have given the reference in my Lord's bundle. We accept, I can't escape from the fact that at paragraph 15 of his judgment, Mr. Justice Tomlinson, referring to the decision in the OT Sonia, did say, in my judgment, the decision in the OT Sonia is not determinative for the present application. I entirely accept, indeed I'm bound to do so, that the words in Article 3, Rule 6 are apt to cover goods which, although intended to be loaded, were in fact never loaded, from which it necessarily follows that the words must likewise be capable of application in respect of events occurring before loading begins. So Mr. Justice Tomlinson is there saying that the rules can apply before loading begins, but in our submission that needs to be considered in context, which is that in the OT Sonia or the OT Sonia the goods never actually ended up on board the vessel, but the claim still arose out of part of the loading process. If, however, one looks at the actual claim in the Linea case being considered by Mr. Justice Tomlinson, the relevant claim for these purposes was the defendant's counterclaim, which was contingent on it being held to be party either to the contract contained in the bill of lading or the antecedent freight contract. And it was common ground that both contracts were subject to the Hague Rules. And the counterclaim was that when the barge presented for loading, it was unseaworthy, which meant that repairs had to be carried out, causing loss and damage in that expensive equipment and personnel were on standby for 7 days, not able to perform the loading work for which they were being paid. The carrier relied on Article 3, Rule 6, and the defendant argued that there was no sufficient connection between their counterclaim and the goods so as to engage Article 3, Rule 6. Having noted the decision in the OT Sonia, as I've already referred to, Mr. Justice Tomlinson concluded that the claim was within the ambit of Article 3, Rule 6, so the counterclaim was time-barred. He held that the claim related to the goods which were in fact carried, which they were, because it related to the expensive and specialist equipment specifically engaged for the task of loading. But specifically, if one looks at paragraph 9 of the judgment, the judge set out there the fact that there was some uncertainty as to precisely what the facts were. This is page 697. And he concludes by paragraph 9, having set out the evidential uncertainty, by saying, I was invited for the purposes of the preliminary issue to assume the loading operation commenced on or about the 7th of June, and that it was suspended between the 14th and the 21st of June as a result of the unseaworthiness of the barge. So on the assumed facts for the purposes of the preliminary issue, the loss was felt during the course of loading. Because the barge was unseaworthy, a clear breach of the Article 3, Rule 1 obligation, it related to the goods that were ultimately loaded, and it is in our submission unsurprising, therefore, that Mr. Justice Tomlinson concluded that Article 3, Rule 6 was engaged. And so, on that basis, we say that the comment that my learned friends rely on doesn't take them any further, because on a proper analysis of this decision, it was entirely driven by the same analysis that we contend for, that is to say that it was necessary to identify a wrongful act by the owners during the period of responsibility. So those are the English authorities. The international cases we set out in our written case, and I'm going to deal with them briefly, if I may, because in our submission they do establish a consensus. But even if they do not establish a consensus, whatever one means by consensus for these purposes.
What do you say consensus means then?
My Lord, first of all, starting, if I may, at the wrong end, the decisions we have internationally, all of them reach the same decision, bar one obiter minority judgment, which my learned friends rely on particular. So in that sense, the outcomes are unanimous. The question of whether a consensus is established is again, I'm coming to the answer, my Lord, but it is only relevant because it would be particularly important to have regard to the foreign cases, and I think that's my Lord's speech in the CMA Libra, paragraph 42. If there was a consensus, it would be particularly relevant to have regard to the foreign cases. But even if there is no consensus, where there are a large number of cases, or we say a number of cases, the court should nonetheless try to harmonise the international interpretation, if possible. And so if there is no consensus, we should be looking at the cases. If there is a consensus, we should be having particular regard to them. And so in one sense, whether there is or is not a consensus doesn't matter for the purposes of looking at the cases, but in our submission where all the cases say the same thing, that doesn't amount to a consensus. There's no numerical magic about the number of cases that would amount to a consensus, or test the matter the other way around. If there are a number of cases, some one way and some the other way, but a small majority one way, I couldn't say that was a consensus. It was a small majority of the cases one way. But if all the decisions of the relevant foreign courts go one way, and we submit they do, then that is a factor which we would respectfully suggest this court should take into account. My Lords have it in the bundle. I don't think we need to turn it up. What Lord Hope said in Morrison KLM, to page 709 of the bundle, at paragraph 81 at page 739, careful consideration needs to be given to the reasoning of courts of other jurisdictions, particularly those of high standing. Considerable weight should be given to an interpretation which has received general acceptance, and in that sense, general acceptance may be a more useful test than consensus. On the other hand, a discriminating approach is required if the decisions conflict or if there is no clear agreement between them. But my Lords, whether it amounts to a consensus or not, what we have is a body of international jurisprudence that, in our submission, supports our case. And the first of that is the decision in Malaysia in Rambler Cycles, which I referred to earlier, 1195 of the core bundle. this was a case that involved misdelivery after discharge. And my learned friends submit, and in one sense that they're right, at paragraph 142, that the Federal Court proceeded on the basis that Article 3, Rule 6 only applied to claims for breach of an Article 3 obligation, which is
Sorry,
not.
what page is that?
It's paragraph 142 of their written case page.
Oh, sorry, I was looking in the case. I thought you were referring to the case.
I was sorry,
Yeah.
my lord. I was giving the cross-reference to
Yeah,
my learned friend's
okay.
written case. Paragraph 155. They distinguished this case on the grounds that the Malaysian Federal Court proceeded on the basis that Article 3, Rule 6 was only engaged in relation to breaches of the Article 3 obligations, which of course is not the position as I've accepted under English law. But nonetheless, we submit that Lord President Thompson's judgment makes it clear that there were two limbs to his approach. The first one can see in the right-hand column at page 1199, where, as I say, and we accept, he does proceed on the basis that Article 3, Rule 6 is only engaged in relation to breaches of Article 3 obligations. But he also focused separately, we say, on the fact that the rules as a whole only apply to carriage of goods, which covers the period from loading to discharge. And that begins at the right-hand column of page 46 of the judgment at page 1199. Paragraph right in the middle of the page, paragraph 6 of Article 3 deals with claims in respect of loss or damage to the goods and commences by providing that notices must be given. Then it says, and he sets out the provisions of the rule. Then over the page at 1200, approached purely as a matter of construction, all this leads to the conclusion, and he's been referred to all the provisions that I took my lords to earlier, all this leads to the conclusion that the Act has no relation into anything that happens to the goods after they're discharged from the ship in which they have been carried. So that is the kernel of the Lord President's decision.
Sorry, can you just tell me exactly where that is again?
Page 1200, the first full paragraph in the left-hand column.
Yes, thank
So
you.
the Lord President has set out all the provisions that we rely on as establishing the meaning of Article 3, Rule 6, and then says approached purely as a matter of construction. And then he goes on to discuss the issue further. And then, if I can refer finally, page 1201, the last paragraph of the left-hand column, that's the carrier's contract may as a matter of general law extend, as in the case of a through bill of lading, before and after that period. So that's before and after the period of responsibility. But insofar as it involves liabilities before and after the period, it is subject to the general law of the land and is not in any way subject to the provisions of the Hague Rules. In any circumstances, whereas here we have a limitation provision occurring in the body of the rules, it can only be held to apply to a portion of the contract, notionally, physically or temporal, which is subject to the rules and can have no application outside its ambit. That is, in our respectful submission, precisely on point with the issue that my lords are considering in relation to the Hague Rules. The other members of the court in Rambler Cyclones essentially agreed with the reasoning of the Lord President, Chief Justice Wee and Chief Justice Wiley. And the other Malaysian decision that my learned friends, we rely on and my learned friends invite my lords to place no weight on, is the decision in Min Metals. It's 143 of my learned friend's written case, page 1054 of the core bundle. And they say it simply follows the decision in Rambler Cycles and therefore takes matters no further. But in our submission, it is another decision of an appellate court adopting the same reasoning and therefore does form part of the background of international law that my lords should take into account. And it's also important to note in our submission, although none of us have specifically referred to it and it's not in my lord's bundle, at paragraph 57 of the judgment, page 1068 of the bundle, the Court of Appeal referred to the fact that there had in fact been another case in the meantime, PT Carrier against Ocean Masters Marine, which had reached exactly the same conclusion. So 3 decisions in Malaysia. Turning then to the position in Australia, which my learned friends deal with at paragraph 144 of their submissions, page 156 of the bundle. That's the decision in T's, which my lords...
Have the page number again, please.
It's paragraph 144 of the written case, page 156 of the bundle, but for the case, page 1213.
1213.
Or starting, I should say, at page 1205, T's Brothers. First of all, my learned friends submit that this case, as in Rambler Cyclers, was based on the notion that Article 3, Rule 6 only applies to liabilities which arise under Article 3. But in essence, we make the same submission in relation to this case as we do in relation to Rambler Cycles. Although that formed part of the reasoning, it is clear from page 1213 that in T's, Mr. Justice Cooper also adopted the same approach that we invoke. Beginning in the middle of the page at 1213, the time bar contained in Article 3, Rule 6 only applies to discharge the carrier from the liability to which it becomes liable by virtue of the operation of the rules contained in Article 3 and the risks contained in Article 2. Time bar has no application to any liability arising outside those parts of the contract of carriage to which the rules have an application. Any liability of the carrier in respect of the period not covered by the operation of the rules falls to be considered in accordance with the general law. So Mr. Justice Cooper is, again, as the Lord President did in Rambler Cycles, looking at it from two slightly different perspectives. Next is the decision in Ji Zhanku, which is the case my learned friends particularly rely on, 1172. Sorry, I'll put it in order. Paragraph 146 of their written case at page 157, the judgment at 1172, beginning at 1167. And in this case, Chief Justice Gleeson concluded that the contractual time bar, in this case in Clause 10, a 9-month time bar, applied, so it was not necessary to consider the applicability of Article 3, Rule 6. My learned friends place particular weight on the judgment of President Kirby, who did analyse the position under Article 3, Rule 6, but neither of the other members of the court expressed any agreement with him. In that sense, it's a minority decision, and in any event, it's obiter, given that he, like the majority, concluded that the contractual time bar applied. It is correct that the President in that case concluded that Article 3, Rule 6 could apply outside the period of responsibility. But in our respectful submission, for all the reasons I've given to my lords earlier, his decision in that respect is wrong. And in particular, nowhere in his judgment does he engage with the importance of Article 1 or the importance of Article 2 as being the provision that engages Articles 3 and 4. And so, in that sense, one single minority obiter lone voice does not disturb what we submit is otherwise a consensus or certainly a body of international law.
So is page 1172, is that where we find President Kirby's reasoning? I'm just trying to figure it out.
The President's analysis of Article 3, Rule 6 begins at 1189, my lord. I'm sorry, I should have given that more clearly. And in particular, he focuses at 1190 on the fact that the breach, he says, is a breach of the obligations in relation to custody and care, overlooking the fact that that is custody and care after discharge and therefore outside the period of responsibility. The next case in the international jurisprudence is the decision of Mr. Justice Marks in a case called Camil, which my lords have beginning at 1036. And my learned friends deal with this at paragraph 148 of their submissions, page 157 of the core bundle. And in essence, their submission is that Mr. Justice Marks failed to grapple with the substance of President Kirby's decision in Zhejiangku. But in our submission, that misses the point. The issue considered in Camel was specifically, does Article 3, Rule 6 apply in respect of loss after discharge but before delivery? Mr. Justice Marks did refer to the judgment of the President, but he rightly said at 1048 that in his view it stood alone amongst other judicial pronouncements, and he referred to Rambler Cycles and the other cases which we've taken my lords to, and concluded that they expressed the law correctly. In fact, he specifically said at 1049 that the weight of authority supported the conclusion the time bar did not apply. The other members of the court agreed. My learned friends then say at paragraph 149, page 158 of the bundle, that the decision in the Nikolai Malakoff adds nothing, and that's at page 1094, sorry, starting at 1074 of my lord's bundle. But that is another case concerning the applicability of the time bar where cargo was misdelivered whilst stored ashore. Sorry, my lords. Sorry, my lords, I've done myself a disservice. This case did not concern misdelivery. This was a case of damage whilst the goods were stored ashore. So none of the issues that might arise concerning whether this was breach of a Hague Rules obligation or not arose. And in this case, Justice Cole's view was that because the damage was caused ashore after discharge, the time bar did not apply. So again, we submit that supports the proposition that there is a consensus. But if there is not a consensus, there is nonetheless, as I've said, a body of international opinion, all pointing one way. And in contrast to the English cases, most, if not all of those cases, being expressly on point. So, my lords, I'm going to move, if I can, briefly on to the Travo, because we submit that looking at the rules as a matter of construction and looking at the international authorities and looking at the principles set out in the English cases, there is in fact no real doubt about what the provisions mean. Nonetheless, it is permissible to use supplemental material such as the Travo to confirm a meaning, and that undertaking that exercise, as this court pointed out, paragraph 32 of the judgment in the JTI Polska case, which is at page 652 of my lord's bundle, it is appropriate to look to the Travo for confirmation of the meaning. And when doing that, there's no need to identify what's previously been referred to as a bullseye. The relevant passages of the Travo are all set out in our written case, and I don't propose to labour the point by going through all of them today. We do submit, however, that the following key points are important. And the Hague Rules were originally a product of a conference in 1921, at which stage it was hoped, as Lord Justice Males said, that they would be voluntarily accepted by owners. They were then put to an international conference in 1921, at which Sir Norman Hill, essentially speaking for the owners, gave a speech describing what he said was the fundamental importance of freedom of contract, and stressing the extent to which the owning community wanted to ensure that that freedom of contract was limited to the less extent possible. And one could see that at page 1260, 1261 of the Travo in my lord's bundles. But the recommendation of that conference was we see at 1264 that the rules should, as they left The Hague, embodied a bargain. And at 1265, Sir Norman Hill pointed out the following: the rules control only the actual sea carriage. They are applicable only from the time the goods reach the ship's tackle. The ship owner is left as free as, but no freer than, every other trader to make his own terms in regard to all other services he renders, as collecting, receiving, distributing and forwarding agent. That would include, we say, complete freedom of contract after discharge for a shorter limitation period. Again, that conference was followed, as I've said, by the International CMI Conference and a diplomatic conference in 1923. And we've set out in our written paper the comments of Mr. Simbale, who represented Denmark, at page 1279, where he said he had earlier proposed that the rules should be it should follow the whole period following receipt of the goods until delivery, but he wasn't going to make that point again, essentially because he knew it had no prospects of success. And one can then see in the debate about the wording of Article 1E, if I could ask my Lords to have page 1280 open. There is a debate in this version of the Travo. One sees in italic letters the wording of the rules then being considered and then followed by, in normal type, summaries of the debate. But what one can see is that the wording of Article 1E, so the important provision I took my Lords to earlier, changing from being, first of all, unloading from the ship's tackle to when they are unloaded from the ship's tackle, over the page to 1281, the time they are delivered from the ship, and ultimately the wording at 1283, the time they are discharged from the ship. So there is a conscious decision. Time doesn't permit to go through all of the debate that was going on, but there was a conscious decision in the definition in 1E not to use the word deliver, but to use instead the word discharged from. And the importance of restricting the rules to the period ending with discharge is reflected in that. And when Article 3, Rule 6 was debated, and if I could just give my Lords the reference at 1286, 1287 and 1288, there was extensive debate about whether the period should be 2 years, 1 month, 6 years, various proposals put forward, but no debate at all about whether Article 3, Rule 6 would apply outside the period of responsibility. And that was a fundamental point for the owners, that everything they were conceding in the rules should be constrained to the period of responsibility. And that is why Article 7 was so important to them. And if one looks at Article 7, again, if I can just give the references, it's page 1300 onwards, one can see it tracks Article 1E in that the words that eventually became discharge in Article 7 started life by referring to leaving the ship's tackle, and then there was a reference to delivery, and then that was changed to discharge. So both in Article 1E and in Article 7, deliberate decision not to refer to delivery, to refer instead to discharge, and therefore to ensure the compromise set out in the rules applied only to the period between loading and discharge, and nothing, as I've said, in the discussions about Article 3, Rule 6, to lead to a different conclusion in relation to that provision. And so, in conclusion, it's our submission that as the Court of Appeal held, Article 3, Rule 6 of the Hague Rules is confined to the period of responsibility as much as all the other provisions of the Hague Rules. That was part of the compromise negotiated at length leading to the Hague Rules, and is a distinction that has been respected and recognised in all the international jurisprudence and should, in our submission, be recognised in this jurisdiction as the Court of Appeal did. If we're wrong on that, the question of whether the Visby amendments change the position doesn't arise. But our next point is to deal with the Visby amendments in essentially the same order as I dealt with the original Hague rules. It's common ground that the Visby amendments were intended to ensure, in relation to Article 3, Rule 6, that the time bar applied to cases of misdelivery and indeed to other cases where there was no physical loss of or damage to the goods. And it's common ground that wide wording was used to achieve that. The question for this court in our submission is whether that wide wording also was intended to and did achieve another consequence, which was to make the time bar applicable outside the period of responsibility when it had not previously been. Our submission is that the intent and purpose of the amendment to Article 3, Rule 6 was to make clear the position in relation to issues such as Issue 1 in the OT Sonia, i.e. whether purely financial loss with no loss or damage to the cargo were within the scope of Article 3, Rule 6, within the period of responsibility, and to make clear the issue resolved in the Alani, i.e. whether the rules applied at all, the time bar applied at all to misdelivery. Those were both open questions at the time of the Visby Protocol, certainly as a matter of English law. And indeed, my lords will have seen references to an article by Michael Mustel QC, as he then was, which my lords have at 1480 of the bundle, where he argued that even after the Visby Protocol, Article 3, Rule 6 was not sufficiently clearly worded to be engaged in deviation cases. So there was a very real issue about the reach of Article 3, Rule 6. So, starting, if I can, with the actual wording used, which we say was intended only to resolve that issue and not to widen the temporal scope. The first, second and third paragraphs remain as they were. In the third paragraph, there are some amendments at the start to accommodate the new Article 6 bis. And, my lords, perhaps in the core bundle, the easiest place to find the two versions next door to each other is in the appendix to Scrutton on Charge Parties at page 997. As one sees the original wording in normal text at the top of page 997 and the new text in italics. This appendix to Scrutton for some time has set out the text of the original rules and then the text of the amended rules in italics or underlined. So the original rules: in any event, the carrier and the ship shall be discharged from all liability in respect of the loss and damage unless suit is bought within 1 year after delivery of the goods. So we've looked at that. And the new rules, subject to the paragraph 6 bis, the carrier and the ship shall in any event be discharged. So those words are essentially the same. And the change is from all liability whatsoever in respect of the goods. So we've changed from all liability in respect of loss and damage to all liability whatsoever in respect of the goods. In our submission, that wording is directed towards the nature of the claim, to remove the requirement for the liability to be in respect of loss and damage, and to make clear that the liability that is discharged by the time bar is any liability or all liability in respect of the goods, or liability whatsoever in respect of the goods. That change of wording is not in our submission if we are right and Article 3, Rule 6 of the Hague Rules did not apply outside the period of responsibility, to change that position. And that in our submission is confirmed by the fact that there is no change to the relevant words of Articles 1E, 2 and 4. So all of the provisions of the Hague Rules which we rely upon, including Article 7 as well, are unamended. And if they, as we say they should, led to the conclusion that the Hague Rules time bar only applied within the period of responsibility, the change in the wording of Article 3, Rule 6 is not sufficient or sufficiently clear to indicate an intention that it should now apply outside the period of responsibility. And the flaw with respect in the judgment of the Court of Appeal on this issue at paragraph 71 is that Lord Justice Mayles held that since he had concluded that the natural meaning of Article 3, Rule 6 of the Hague Rules was that the carrier was discharged from all liability of any kind within the period of responsibility, that he'd given a wide meaning to Article 3, Rule 6. The amendment had to do something else, otherwise it was nugatory. But that approach, in our respectful submission, ignores two key facts. Firstly, at the time of the Visby amendments, it had not been settled, even as a matter of English law, as I've already submitted, that the Article 3, Rule 6 time bar applied to discharge all liabilities of any kind. That came later in the Otsonia and in the Alani. Secondly, whatever the position in this jurisdiction, the Travo, which I'll come to in a moment, show that it was an open question in other jurisdictions. And so the Court of Appeal's conclusion that unless Article 3, Rule 6, unless the amendments were effective to apply it outside the period of responsibility, they achieved nothing, was, with respect, wrong. What the amendments did was to make it clear in the rules that they applied in the way that English law has subsequently said the old rules apply. And because this is an amendment to the International Convention, it is all the more wrong to look at it through purely English eyes in considering whether, if it did not have the effect the Court of Appeal said it had, it would be nugatory. On our case, the new words significantly widen the subject matter scope of Article 3, Rule 6, and that is what they were intended to do and all they were intended to do. There's no domestic authority directly on point, but the one decision in this context, in the Hague Rules, Hague-Visby context, is the decision of the Court of Appeal in the Captain Gregos, which I referred to earlier and I'd like to go to briefly if I may. At page 512 of the core bundle, and this was a case of misdelivery during the period of responsibility. The allegation was essentially that the owner had pumped the cargo into the vessel's fuel tanks to burn it for themselves. At first instance, Mr. Justice Hurst had held that the Hague-Visby time bar was not apt to cover such a claim, and that was the key issue that the Court of Appeal was looking at. Lord Justice Bingham started his judgment at page 515 of my Lord's bundle, top of the page, first full paragraph. The starting point of this inquiry must lie in the rules themselves scheduled to the Carriage of Goods by Sea Act 1971, the whole scheme and effect of the rules is in some sense relevant to our task of construction, since the rules represent a negotiated bargain between the ship owners, whose interest lies in maximum immunity, and the cargo owners, whose interest lies in maximum redress. And that, again, it reinforces the point I've made that it's necessary to look at the whole of the rules rather than simply Article 3, Rule 6 in isolation. Lord Justice Bingham then proceeded to consider, sets out the rules as we see at page 515 and 516. And then at 518, if I can pick up there, in the middle of the page, the contract of carriage here was of an entirely normal kind. The cargo owner's counterclaim arises as parties to the bill of lading, which I shall at this stage assume them to have been, against the ship owners as carriers. It's a paradigm situation. The definition in Article 1, paragraph E, does, I accept, assign a temporal term to the carriage of goods under the rules, supporting an argument that the rules do not apply to events occurring before loading or after discharge. Of course, in this case, that didn't matter because the misappropriation of the cargo had happened after loading and before discharge. And then Lord Justice Bingham says, see also Article 8. I read Article 2 as defining... Seven. I read Article 2 as defining the scope of the operations to which the responsibilities, liabilities, rights and immunities in the rules apply. Apart from the obligation of seaworthiness imposed by Article 3, paragraph 1, not an issue here, the carrier's central obligation is, per Article 3, paragraph 2, properly to carefully load, handle, stow, keep, carry and care for and discharge the goods. And then last paragraph, Article 3, paragraph 6, provides that the carrier and the ship shall in any event be discharged from all liability whatsoever. And it's correct that Lord Justice Bingham there says, I don't see how any draftsman could have used more emphatic language. It's even more emphatic than the language Lord Wilberforce described as emphatic in the New York Star. And obviously, my learned friends pray that in aid of their submission. But in our case, all that even more emphatic language was intended to do was to clarify the point that misdelivery and other purely financial related breaches by the carrier were caught by the time bar. The important thing about Lord Justice Bingham's analysis is that it supports in our submission our case that there is a temporal scope to the rules as part of the compromise that he referred to at the beginning of his judgment. But I accept that because the misdelivery in that case was during the period of responsibility, it's not directly on point. But insofar as it goes, it supports our construction. The international authority, such as it is, and here I would tread a little more carefully in saying consensus because it's only one case and then another case following it. But in Hong Kong, the decision in Chok Yong that my lords have at page 1015 of the core bundle is a unanimous decision.
Could I have the page number again?
1015.
1015, thank you.
It is a unanimous decision of the Court of Appeal in Hong Kong, firstly deciding at 1024, paragraph 36, having referred to the Captain Gregos, that the Hague-Visby rules could cover wrong delivery of the goods, but the relevant question is still, did the wrong delivery occur during an operation that related to carriage by sea? And the conclusion, having referred to Pyrin and Scindia and the other decisions on the Hague rules that I've taken my lords to, the conclusion of paragraph 52, 1029, was that the trial judge had erred when he held the Hague-Visby rules applied in the present case. That was to a case where the breach arose after discharge. So that is, we submit, entirely on point and was followed by Mr. Whitehead, senior counsel, in a case called Perfect Best Asset Management, which my lords have at 1153. Sorry, starting at 1115. And at paragraph 114.2.4 of the judgment, he deals with counsel's attempt to distinguish Chong Yuk Fai because in Chong Yuk the relevant breach occurred not just after discharge but in a land leg, a further leg of the transportation. And at 114.2.5, page 1153, the Alani case was unique in that the cargo, bunker fuel, was discharged and misdelivered at the same time. Although the Chong Yuk Fai case involved a land leg, I agree with Mr. Alder that this makes no appreciable difference. So in considering whether the breach occurred during the period of responsibility, the fact that it in fact occurred during a land leg made no appreciable difference. And the conclusion was Mr. Whitehead followed the judgment of the Court of Appeal in Chong Yuk. And so, as I said, those are the only two decisions we've been able to identify. But they do both follow what we say is the correct approach. My Lords, I don't propose at this stage to take the court through the textbooks and articles that have been written on the subject, because in our submission all they show is that there's no settled understanding between the learned authors of the various works that have been referred to. My Lords have seen what we've both written in our written cases. If the academic writing or articles demonstrated a settled understanding of what the Hague-Visby rules meant, or indeed the Hague rules meant, that might be something that either party could pray and aid, but they cut both ways, and in those circumstances simply showing you books where authors have said either what I submit or what Mr. Rainey submits is right is not going to take matters very much further forward. And
so that applies to the Hague rules and the Hague-Visby rules, is it?
My Lord, I think so. Most of the works that have been referred to are the most recent edition. I'm pausing because we've got some old editions of some of the books, but most of the books we've only got the most recent editions, which by definition are dealing with only the Hague-Visby rules, and indeed some of the books have only been in publication since the Hague-Visby rules, so there wouldn't be an edition dealing with just the Hague rules.
Well, it's not, they don't necessarily confine themselves to the Hague-Visby rules, do they? It's still relevant to consider the Hague rules.
My Lord, yes, but I've not identified anything that is clearly one way or the other, either in relation to Hague or Hague-Visby, is perhaps the more correct answer to my Lord's question. And my Lord, apart from, we'll come back to Carver in relation to the Carver implied term in a moment, but apart from the editors of Carver, where I could make a forensic point that their enthusiasm for what my learned friend says is the correct outcome has somewhat diluted between the 4th and 5th edition. There really isn't anything I could usefully point my Lord to. So I propose to move on, if I may, very quickly before the break, to the Travo. And in our submission, the most important point is that the overall structure of the rules has not changed. There's no change to Articles 1, 2 or 7. The key takeaway from the Travo is the complete absence of any indication that it was intended to widen the temporal scope of any part of the rules, still less Article 3, Rule 6. The genesis of the Visby Protocol, my Lords can pick up at page 1273 of the core volume in what we've called the Berlingueri Travo. There are two sets. The CMI established an international subcommittee to look at two issues after the war: the scope of the application of Article 10 and the limit of liability. And that subcommittee produced a report which was considered by the CMI conference in 1959. Pausing there, With apologies, in our written case it says 1953. I'm solely responsible for the typo, for which I apologise at paragraph 75.1. But as well as dealing with the Article 7 and limitation, the report of that subcommittee also raised various, quotes, additional problems. If I could just refer, my Lords, page 1275, I'm afraid we only have it in the French, but I think it's clear, or I hope it's clear, the additional problems raised in the report to the conference start here at 1275, and the very last one, my Lords will see limitation et prescription en matière du dommage indirect, and then délai livration aux personnes qui n'y avant.
Mr. Livery.
I apologise for mangling the French, but in any event, I think it's tolerably clear that the
Delivery to the wrong person, I think.
Delivery to someone who
Not entitled to delivery.
Yeah.
So, delay and delivery to a person not entitled. And that is repeated again at page 1277. So it's clear that the committee have identified those as being other issues. And indeed, in due course, as we set out in our written case, the subcommittee considered various subjects when it produced its final report and made positive recommendations into some, which are set out at 1318 and following, and also set out its conclusions on other subjects examined. And those appear at 1322, and it's important in our submission that one of the issues which the subcommittee considered under the subject of other subjects examined and recommended maintaining status quo was liability before loading and after discharge. So Article 1E and Article 7. That's 1323 of my Lord's bundles.
And sorry, this document, this is a report coming out of the earlier debates, is that right?
No, this is a record of the report by the subcommittee that was put. So that's the subcommittee I already referred to.
Yes.
That was eventually presented to the 1959 conference.
So sorry, is this right? That the document in French you showed us, that's the document setting up the meeting for the subcommittee, and this is what comes out of the meeting of the subcommittee?
That is my understanding, although it's one of the difficulties of having two sets of travaux that don't exactly marry up, but we've done our best to assist in terms of the chronology. And so there are other subjects examined, as I've said, and the time limit. Giving myself the wrong reference. 1323, other subjects examined included widening the scope of the period of responsibility. And the recommendation for that is over the page, the subcommittee recommends retaining the status quo on these points. They could see no reason for changing the status quo. On the other hand, in relation to the time limit for claims for wrong delivery, which is at 1319, that did form the basis of a positive recommendation that was made. And at that stage, there was a positive recommendation that there should be, one can see the majority decision of the subcommittee at 1320, an amendment to Article 3, Rule 6, not the amendment my Lords have seen. This was an amendment to say, provided that, in the event of delivery of the goods to a person not entitled to them, the above period of 1 year shall be extended to 2 years. So this was creating a new standalone time limit for misdelivery of 2 years. In our respectful submission, if it had been the intention of those recommending a change to Article 3, Rule 6, that it should also apply outside the period of responsibility where it hadn't previously, one might have expected to see that referred to either in the section of the report dealing with liability before loading and after discharge, or in the section dealing with Article 3, Rule 6, and there's no suggestion anywhere that that was taken into consideration.
Was any reason given in this text for the different period in relation to misdelivery?
My Lord, not in this text, but there was subsequent debates at the conference as to whether there should be a 2-year period or a 1-year period, and also as to whether the wording should be as originally proposed. And one can track through in the other Travo, and I'll pick up the cross references if I may. Firstly, to point out 1321, 2 points. There was concern that by applying the time bar to misdelivery, that might prejudge the question of whether the rules apply to misdelivery at all in jurisdictions that held that they did not. And the subcommittee made it clear that the amendment did not imply that they were prejudging that issue. And a minority put forward a different wording at 1321. What happened thereafter, my lords can see at page 1325 onwards, is that the maritime law committees of various member states submitted papers with their observations on the proposals. Time does not permit me to go through all of them in detail, but I can summarise the position, I hope accurately, as follows. Most states were broadly in favour of the proposal to change Article 3, Rule 6. Sweden suggested 1 year instead of 2, that's page 1330. The United Kingdom, 1335, suggested 1 year, but with a different wording. Norway supported Sweden, arguing for 1 year for all claims, including delay in delivery. I'm afraid I left out the reference to that. Ms. Morton will just pick up the reference for Norway. And the United States also supported Sweden, but was concerned that the wording might prevent agreed extensions of time, and therefore suggested a different wording, 1356. It is of note that apart from Norway, and here I do have the reference, 1348 is the reference to Norway, apart from Norway, none of those maritime law associations who submitted comments on the proposals disagreed with the suggestion that the period of responsibility should remain as it was. So everyone agreed that in relation to Article 1E and Article 7, the status quo should be maintained. And there was a consensus, therefore, for change, for a 1 year limit, to answer my Lord's point, rather than 2. And that is summarised by Mr. Moore of the United States when he addressed the plenary session of the subsequent conference, which we have on the 10th of June, 1367. And my Lords, I'm conscious of the time. I can go on to the next stage in the Travo.
If you're comfortably within your time limit, this may be an appropriate point to adjourn. But I would like to know, if there is evidence, what the thinking was initially for having a different period.
By different 2 years rather than 1.
2 years rather than 1, thank you.